arbitrators, many of them. Start off with a question. We have witness statements ordinarily in international arbitration. Gives us an opportunity to consider the value of that testimony. Cross-examination is not the only response to the witness statement. You can ignore it, hope it goes away, or it doesn't matter. You can choose to rebut it later. How do you decide whether to cross-examine?
Well, I think, as Ben suggested in his opening remarks, Larry, that most of the time these days, it's almost universal that cross-examination as a right is exercised. I have had the experience a number of years ago in a case involving an American party and a Mexican party, where the American party, represented by a very assertive trial counsel, exercised the right of cross-examination quite vigorously on every opportunity, and the Mexican party never cross-examined a single witness. And it felt very uneven, and we were concerned as a tribunal about that. In the end, I have to say the Mexican party prevailed in the case, but they did not cross-examine. It was simply something that none on their team was prepared to do. And it was a very odd sensation listening to that case being developed. Now, on the other hand, when the American counsel cross-examined in his rather vigorous way, my Mexican colleague on that tribunal was extremely uneasy. And in our deliberation room a couple of times, he was very upset. He thought it was rude, he thought it was aggressive, he thought it was unnecessary. And so he was very perturbed, and the appointee from the American party on the other side of me and I tried to soothe him and say, no, well, it's not, he's aggressive, it's true, but he's not out of line, and he's entitled to do this. And we told the parties ahead of time that there would be a right of cross-examination. Nonetheless, it was a very unbalanced experience. And so I would say it's rare when you would not cross-examine. If you're not going to cross-examine, the usual technique is you simply inform the party ahead of time and you leave the tribunal simply to read the witness statement that's been prepared so that they never see the witness.
Now, as an arbitrator, have you ever said, well, they don't want to cross-examine, but we, as a tribunal, we want to hear?
Yes.
So bring the witness in?
I have done that on a couple of occasions. It's not often done, but have done that. And in fact, quite recently sat on a case where the claimant party had an expert witness. They had them in the room ready to answer questions, and the respondent chose not to cross-examine. And I had questions for that person. And I allowed counsel, if they wanted, to cross based on any answers arising from my examination as an arbitrator, but they both elected, they left him alone. And so any questions of that witness on the record were simply my own. Not a usual situation either, but it does happen.
Frank Vasquez, do you have any thoughts on this?
Yes, yes, I do. I think the first question is a very practical one, which is how much time are you going to have for this hearing and how many witnesses are there? And you may need, because of the amount of time you have to cross-examine, decide it's not worth it to cross-examine certain witnesses because you need to spend that time doing other things, either arguing your case or something else. Then I think the next question is, what is the role of this particular witness in the case? Are they affiliated with the party? Do they have a very small statement that doesn't do much for the case? And if they are affiliated with a party, if they are carrying a lot of the burden, that's the kind of witness you probably do want to cross-examine. And even if you have to, your cross-examination may be brief in certain circumstances because you may just want to establish that this person actually doesn't know what they're talking about or doesn't know the important facts of something. But then there's also the other question is, can you really get something out of this person based on the documents that they've written or what they've said in the case that's going to really help you in your case? And I think that's the third consideration that I would look at. But this is in my practice, you know, when we all get together, our team is in an arbitration, this is one of the questions we sit down and debate. All right, there's 20 witnesses in this case we could potentially cross-examine. Which ones do we think are the ones that we want to actually bring in, given the constraints we have and given what we think we can get out of them?
Now, suppose there's a witness who's put in a witness statement, and you don't really have a way of cross-examining. Can you just hope that that witness statement will somehow get lost in the welter of documents, and perhaps it won't be paid attention to? George, what do you think about that?
I think that's a rather vain hope. I usually don't operate on hope. I'd also like to, suggest that this talented group of lawyers could figure out some way to cross-examine on any witness statement if they thought it was important. But I think it raises the interesting issue, which I'd be interested in the reaction of some of the folks who have been arbitrators, as to when you don't cross-examine a witness on a witness statement, what do the arbitrators do with that witness statement? I've heard the other side assert, when we haven't called a witness, well, that witness statement is undisputed, and it is in the record, and it cannot be disputed. I think that's an overstatement of the value of the witness statement. After all, there are a lot of other documents, there are other witness statements, there are going to be cross-examination at the hearing of other witnesses that may or may not contradict what that witness statement says. But that would be the one concern I would have, is that it stands that the arbitrators may consider it. But if it's not material, and I agree with Frank, I think that's ultimately the evaluation. Is this witness statement material? Does it undercut an important element of our case? If not, then I may pass.
Sophie, as an arbitrator, what the other occasions when you feel that you want to hear the witness and the parties seem somehow not to, or the party against whom the witness statement has been offered just decides not to present the witness?
It has happened, and when I have questions, I do ask them. I have absolutely no bones about that. Obviously, I don't cross-examine aggressively a witness. I'm looking to elicit information, so I will not ask a closed question. I'm quite happy for the witness to elaborate. So that's the advocate's risk as well. If they do not cross-examine and then the tribunal steps in, they lose control, as Ben was rightly saying, of the witness. The other, to come to the very interesting point about statements that are left untouched and left to stand, it may well be that the tribunal takes it that that witness is telling the truth. And there is one of the, I think, the foibles, I don't know if Ben agrees, of any cross-examiner is a truthful witness. And here I have, if I may draw attention to my colleague, Mr. Baker, who's hiding in the room, with whom I have the privilege of sitting right now. He calls this the dead horse theory. And I wish I could say that with his Texan accent, but I cannot. But essentially, we are sitting in a case right now where counsel, I think perhaps inexperienced counsel, just kept coming and coming at the witness, who was not wavering, and so very clearly telling the absolute truth that they believe to be the truth. And Mr. Baker said, counsel, don't flog a dead horse. And I think that's very good advice.
Well, is it correct, Sophie, that as an arbitrator, you somehow absorb better information that's given to you orally or in writing? That is to say, if a witness comes in with 10 paragraphs of a witness statement, it's among many other documents, you read it, maybe on the plane or something, and then somehow it doesn't penetrate the way it would if the witness came in, you saw this person physically, and there was challenge, and there was conflict and drama. I mean, is that a psychological reality that people should take into account?
demonstrate this afternoon. I hope that physical presence is more compelling than just reading a statement. And I think undoubtedly when you read a statement and then you see the actual author, hopefully, or the actual witness making the statement, then that statement takes on a life of its own and imprints itself in your mind. And so, hence, I imagine as well the importance of witness preparation and the whole business of witness coaching, which can be overdone as well. This is a whole other issue that I'm sure we can talk about. But definitely, there is a huge element of psychology in international arbitration that is underexplored, and that's one prominent example. Yes.
Have any thoughts about when you're formulating a witness statement, you don't want it to be forgotten. You want it to be challenged. I mean, if you're going to be clever about this, perhaps you put something in that will have to be challenged, but can be dealt with. I mean, am I suggesting something's too clever? I mean, Carlo, do you have any thoughts on that?
Well, let me just make a preliminary remark. I'm probably taking the example that was done at the beginning. I'm probably the Mexican on the panel, meaning that I come from the civil law jurisdiction, and we are certainly not familiar with the process since we start our profession, and it's always a challenge when you have to take decisions as to cross-examination in international arbitration. That's something that really is not yet in our DNA, and so I believe the young generation of professionals who are working in international arbitration have become increasingly familiar with that process. I hope to be still in the young generation, so to be part of that. But there is a reason for that, which is that the civil procedure rules that we have simply prohibit us from asking questions to the witnesses in court. And there are also other rules that make it something from another planet, so to say, for us. Having said that, I do have experience now about the process and the cross-examination, and I must say that for us, I mean, there are additional issues that we have to discuss and decide as lawyers, as counsel, like, for instance, the language of the cross-examination, whether you want to have translation or not. And sometimes you ask yourself the question, well, I mean, if I have a witness that will not come across as strong as he could be, is it going to be better to protect him by allowing him to speak in his own language, which is good, but with the downside that you will have simultaneous translation and something will get lost in translation. So you have those kind of additional hurdles and question that you ask yourself. But I do believe, as it was said before, that there is some advantages. The question that you raised is really an interesting question. I mean, is it going to be more convincing to hear something from someone live? And there are cases in which arbitrators ask, in the terms of reference, that every witness statement, the front page of a witness statement should have a picture of the witness so that they remember the face. I've seen those cases, and I think it's useful because then several months after you have done the hearing, you will go through the witness, probably as an arbitrator, you will go and read the witness statement, and you remember the face and the guy who was good or bad during the cross-examination. I think those are important things that we should get more familiar with.
Do any of you actually think we really want this witness to be on the stand, and we want to make sure that the witness is heard and not just having his statement buried? Is there any way of doing this? Have you thought along those lines, or as I say, is that too clever? David?
Well, when you're preparing witnesses and preparing their witness statements, I think you become pretty conscious of whether or not they're going to be a good witness. Some people are going to be pretty good at this. They either have had other experiences, or they are the sort of person who speaks with conviction and believes they know what they know and aren't going to be pushed around. you really hope that witness will be examined because they'll be hopefully persuasive and convincing to the tribunal. You also know that you have some witnesses and you think, oh my goodness, this is a very fragile horse. It may get flogged more than once, as to use Mark's and Sophie's metaphor. And you kind of hope that they'll go under the radar. I don't know of any deliberate technique that you would sort of attach a scent to the witness and say, I hope the hounds chase this one because he's going to be very good. And there's also the element of unpredictability. I've seen people get ready for a cross-examination, and you think this person is bold and strong, and they turn into a pussycat on cross-examination. You think, where did that other person go? And I've also seen some very quiet, introverted witnesses get on to cross-examination and hold their ground very quietly and very determinedly, and you think, gosh, that was good. They were very, very good. So it isn't always predictable, but as for deliberately trying to set somebody up as a witness that you really hope will be crossed, hard to say. I'm sorry, I don't think I know a technique for doing that.
Frank?
I think it would be difficult to try and put something in the statement, but I think you do have to go through this when you're interviewing your witnesses to see, well, do we think this person can really carry a lot of water for my case or not? In which case you probably would put more in their statement of substance that would lend to the other side calling them. There is, as part of the pre-hearing conferring, there is a question of whether you're going to be allowed to call your own witnesses, and in some circumstances you can, particularly if the other side of the last word in the briefing, and there's always arguments about that, and sometimes you can convince a tribunal that your witness really needs to testify and maybe give some small direct and then leave them for cross-examination so that they're there. I've had various, David's right, you really don't know what a witness is going to look like once they get up there, but I recall having, one witness, because we had a couple different hearings, and in his first hearing, he was the CEO of our client, and he was just awful, and he was grabbing at his tie, and he looked sweating, and he had all these problems just in the way he appeared, and I ended up having to take him and actually videotape him in preparation, just to show him how he looked, so that just essentially straighten him out so he could perform in front of a tribunal, which was an extreme example, but it is something that you need to keep in mind when you're preparing your witnesses as to whether they're going to be able to present, particularly if it's your client or a key person in your client that you're dealing with all the time. They really need to be able to support the statement that you put in for them.
My experience is that you go through this exercise of telling them how to present themselves effectively, and they forget all about it. They revert to their true selves. George, when nobody challenges your witness statement, they don't want to cross-examine, are you happy? Or do you think, wait a minute, something's wrong here. Either they're stupid or I missed something?
Generally, I'm happy because, flipping my question around, I'm assuming that the arbitrators are going to say, okay, that person wasn't cross-examined, I'm just going to accept their witness statement, assuming there's no glaring contradiction in the record, and therefore it's established, it's in the record, I can argue from that witness statement. But we've already heard references to the fact that you may have someone who's a very compelling witness, and you're very unhappy that that person doesn't appear in front of the tribunal to, in effect, advocate your case. So I have mixed feelings about it, and there's not a lot you can do about it, really. I actually had a case where we didn't call a couple witnesses for the other side, and the other side was unhappy about that. They tried to bring the witnesses in. They proffered them for direct examination. We had an argument prepared to say, look, the procedural order doesn't allow that. The other side's our side's the one that gets to call people for cross. What's the direct examination going to consist of? It's either going to be yes, this is my witness statement, or it's going to be a new witness statement, which is not allowed. Before we even had to make the argument, the chairman of the tribunal said, what's the purpose? And the other side couldn't explain it, and he said, no, I'm not going to allow it. So, you know, it's something that you just have to live with, I think, most of the time.
Well, in international arbitration, there always seem to be deadlines and time constraints, and people gather from various parts of the world, and they've got plane schedules and things are set up, and they don't really want to work past a certain hour. And do you find yourselves suffering under tight time constraints, where you've got an hour to cross-examine a very important witness, and what do you do about that? I mean, any thoughts on that, David?
Well, I think most cases these days are under those constraints, and I'm always impressed when I'm sitting as an arbitrator how well counsel seem to manage to do most of the time. Occasionally you get bunched up at the end and there's some traffic jam going on, and you have to be a little more lenient in the last half day of the hearing just to make sure that somebody doesn't miss an opportunity entirely. But in general, I think counsel get to use their time as they see fit. So on less important witnesses or less critical evidence, they can move along quickly. And when they come to what they think is the key witness or the anchor man on the other side's team, then they use their time as well as they can to really take them through their procedure. Time management is very difficult for lawyers. We all understand that we were genetically unfit to be engineers and mathematicians and so on, and we've got this other small defect. Time doesn't seem to come to our attention when we're on our feet or when we're speaking or cross-examining, and we need really disciplined colleagues to give us a tug or a kick under the table and say, you've got to keep moving.
Sophie, do you find as an arbitrator that putting time pressure on the parties is a helpful thing? It gets them, forces them to get down to business and not deal with on cross with rather relatively minor matters that aren't going to have a material effect on the outcome?
I mean, I'm quite conscious of the fact that I have a duty to be effective, and I have a duty to be to contain costs and time. But at the same time, it's quite important, it's crucial that the parties feel that they have put their case fully to me. So I will make sure that there is no runaway sort of exercise by the lawyers, and that we concentrate on the main points. But I will not put time pressure on counsel that I don't feel is necessary. And if a point is important to them, I will let them ventilate it. That's quite important to me. And I don't, again, count the number of times that we've sat well past 6 o'clock, you know, at night. If a point has to be, and if a witness has to catch a flight that evening, well, we're going to have to finish later, that sort of thing. There has to be that flexibility.
There's two ways of putting time constraints on. One is to have a chess clock. You've got a certain amount of time to use however you see fit, or each witness gets a certain allotted time. Do you set that out, or do you just let the arbitrators figure it? I mean, not the arbitrators, the parties figure it out?
Experienced parties usually figure it out between themselves, and I'm finding, quite interestingly, that the chess clock method is not very popular with them. They like to have the ability to not work under that sort of constraint, and most very good disciplined counsel do it. Now, counsel who are less familiar with the international arbitration process usually prefer the tribunal to keep a record of equal time. It is quite unusual that you have a huge discrepancy between, I mean, you can have a side that, there's always a side that has more witnesses than the other. But I find that usually things are pretty much balanced.
Frank, what do you do if you've got a witness and you've got, say, an hour to cross-examine this witness, and he turns out to be an expert who's an experienced witness and knows how to expand his answers to fill as much time as he can so that fewer questions will be asked of him? What do you do about that?
Well, there's it's difficult. There's a couple of things that you need to do. In all the preparations for preparing for your cross-examinations, I usually prepare about twice as much material as I think that I'll have time for, and put that material in various little modules, so they're little mini cross-examinations that could be shuffled, changed, or used depending on where we are in the case, what the arguments have been made, so that I know that I have these points. But in terms of that witness control, a lot of it comes to asking very tight questions that really call for answers. And if the witness is babbling on, tribunals don't like that, is my experience. And you can call them on it in a way, you don't need to say, to argue with them, but simply say something effective. I don't think you understood my question. My question was actually a lot similar. It's much more simple than that. All I'm asking you is whether you wrote this. And the tribunal will get it after a little while. My experience is that cross-examination, to a large extent, is a contest of credibility between you and the witness. And if you get flustered because the witness is not doing what you want them to do, that counts against you. But if you remain calm and demonstrate to the tribunal, no, the witness is actually avoiding answering the questions or is wasting our time, the tribunal will take that into account in evaluating the witness's testimony. But you really do have to have some experience and be able to trust that process, that the tribunal can see what's going on here. You need to make sure that your questions are as tight as possible so that you do prevent a witness from wandering about where you don't want them to go.
George, do you ever go to the tribunal and say, would you please direct the witness to answer my questions and not go off on some discursive distraction?
Yes, but I would say that one of the things I did in a recent hearing, I've had 2 recent hearings, and I'd be interested in comments of the people who have arbitrated on this too, that the major constraint we got into was with damages experts, because the damages experts usually come at the end of the case. The case is getting more and more compressed, the fact witnesses get longer and longer, and I had 2 cases where the damages part of the cross-examination was an hour. And one of those was a witness conference where there was more than one expert on the other side, and the other one we held over until a Saturday to complete the damages expert. And of course, everybody was sort of languishing at that point. In the second one, I actually said, and it sort of worked amazingly, it was kind of stupid, but I said to the expert, who was a leading damages expert, right up front, I said, look, Mr. X, as you know, we only have very limited amount of time. I've only got an hour to cross-examine you. I'd appreciate it if you listen to my question very carefully and give only succinct answers. And he agreed to that up front. What was he going to say? No, I'm going to filibuster you, so just forget about it, Ruttinger. It actually kind of worked. I could see there were times when I'd ask him a leading question, nice crisp leading question, and he would kind of start thinking, can I agree with that? Do I need to give a lengthy answer? And then he gave a succinct answer, and I was able to get most of my points out in that hour of cross. But, to me, that, I guess I view that as kind of a challenge in a way, that you really have to focus when you've only got an hour or, an hour and a half, whatever, with a critical witness. And I agree with Frank, I usually have an outline that's probably 5 times longer than what I actually am going to ask, but you have to be really alert. Okay, what are the main points that I want to establish? And if you get into a line that's maybe not one of your most important points, and the witness starts digressing, just get off it. Go to your more important points, and be flexible. But